The Supreme Court chamber was a cathedral of law, its marble columns and crimson curtains framing a scene of profound gravity. On this crisp April morning in 2025, the air was thick with anticipation. Justice Amy Coney Barrett, her gavel striking the wooden bench with a sharp crack, brought the room to silence. At 52, Barrett was a formidable presence on the conservative-leaning court, her reputation as a constitutional scholar and former Notre Dame law professor lending her words an unyielding authority. Her voice, steady and precise, cut through the tension like a blade. "Miss Leavitt," Barrett began, her eyes fixed on the young woman standing at the podium. "This court finds your repeated statements about our recent decision deeply concerning. You stand perilously close to contempt." Karoline Leavitt, the 28-year-old White House press secretary, stood motionless, her expression calm but resolute. At just 6 months into her tenure, she was the youngest person ever to face potential contempt charges from the nation's highest court. Reporters in the gallery whispered furiously, their fingers dancing across phone screens. The stakes were monumental. A contempt finding could mean imprisonment, the end of Leavitt's meteoric career, and a seismic shift in the balance of power between the executive and judicial branches. Barrett's tone grew sterner. "You have 7 days to retract your statements and issue a formal apology, or this court will have no choice but to refer this matter for criminal prosecution." A collective gasp rippled through the chamber. The weight of the ultimatum hung heavy, but Leavitt did not flinch. Instead, she opened a sleek leather portfolio, her movements deliberate. "Justice Barrett," she said, her voice clear and unwavering, "I've prepared a 15-page legal analysis explaining why my statements are not only protected by the First Amendment, but also legally correct." The gallery froze. Several justices exchanged glances, their expressions a mix of surprise and curiosity. Chief Justice John Roberts leaned forward slightly, his interest piqued. What happened next would stun the court, the media, and the nation. The confrontation had its roots 3 weeks earlier, when the Supreme Court issued a controversial 5-4 ruling in Fairfield versus Department of Education. The decision, which limited federal oversight of state education policies, ignited a firestorm of debate. During a White House press briefing, Leavitt had delivered a pointed critique. "This ruling represents a fundamental misreading of precedent and legislative intent. The majority opinion ignores 70 years of established jurisprudence and substitutes judicial preference for constitutional principle." Her words, sharper than the typical measured responses from the White House, triggered immediate backlash. Conservative commentators accused her of undermining the court's legitimacy, while legal analysts debated whether her statements crossed the line into contempt. Progressive voices, meanwhile, rallied to her defense, arguing that robust criticism of judicial decisions was a cornerstone of free speech. The summons for Leavitt to appear before the full court was unprecedented. Constitutional scholars struggled to find historical parallels, with the New York Times calling it a constitutional crisis without modern precedent, and the Wall Street Journal describing it as a collision between judicial authority and executive communication rights. For Barrett, the case was a test of the court's ability to defend its institutional integrity in an era of diminishing respect for institutions. For the White House, it raised the question of whether administrations could challenge court decisions without legal repercussions. Leavitt's legal team urged her to apologize immediately, and the White House counsel prepared a statement of contrition. Even the president advised a conciliatory approach. But Leavitt, unbeknownst to many, was no political novice playing out of her depth. A graduate of St. Anselm College with honors in politics and communications, she had quietly completed law studies through an evening program while working on Capitol Hill. Her 3.9 GPA and reputation as a gifted constitutional law student had gone largely unnoticed until now. As Barrett issued her 7-day ultimatum, Leavitt's decision to present a legal defense rather than apologize caught the court off guard. Justice Sonia Sotomayor looked up with visible interest, while Justice Samuel Alito's brow furrowed. Barrett's expression betrayed a flicker of surprise. "Miss Leavitt," she said, her voice carrying a note of warning, "this proceeding is not a debate. The court has made its position clear regarding your statements." Leavitt nodded respectfully. "I understand, Justice Barrett. However, before the court proceeds with its contemplated action, I believe it is my responsibility to address the legal basis for any potential contempt finding." Barrett's eyes narrowed. "Proceed, but be aware that your response here may factor into the court's ultimate decision." Leavitt opened her portfolio and began. "I'd like to start with the legal standard for contempt of court as established in Bridges v. California, 1941. In that case, this court held that criticism of judicial decisions, even harsh criticism, is protected by the First Amendment unless it presents a clear and present danger to the administration of justice. My statements, while direct, presented no such danger. Justice Alito interjected, his tone sharp. "Miss Leavitt, you stated that this court ignored 70 years of precedent. That goes beyond criticism to questioning the court's integrity." Leavitt turned to face Alito directly. "Justice Alito, in New York Times v. Sullivan, 1964, this court established that debate on public issues should be uninhibited, robust, and wide open, and may include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, including judges. My comments address the legal reasoning of the Fairfield decision, not the personal integrity of the justices." The chamber was silent as Leavitt continued, her voice steady and precise. "Furthermore, in Craig v. Harney, 1947, this court held that judges are expected to be men of fortitude, able to thrive in a hardy climate. The opinion explicitly protected criticism of judicial decisions, noting that what transpires in the courtroom is public property." Barrett leaned forward, her expression stern but attentive. "Miss Leavitt, those cases primarily address the rights of private citizens and the press. As a government official speaking in an official capacity, your situation may be distinguishable." Leavitt was ready. She turned to page 8 of her analysis. "Stiamo. Justice Barrett, I respectfully direct the court's attention to Garrison v. Louisiana, 1964, where this court specifically addressed critical speech by government officials. In that case, a district attorney's critical comments about judges were held to be protected speech. The court stated that speech concerning public affairs is more than self-expression. It is the essence of self-government." The tension in the chamber intensified as Leavitt's argument unfolded. Reporters who had expected a swift reprimand were now transfixed, their phones forgotten. Justice Elena Kagan spoke up. "Miss Leavitt, While your knowledge of precedent is noted, there's a difference between criticizing a decision and suggesting the court deliberately misinterpreted the law. The latter implies bad faith. Leavitt nodded. Justice Kagan, I appreciate that distinction. However, in Wood v. Georgia, 1962, this court protected a sheriff's statements that directly accused judges of bias and political motivation. Statements far more pointed than my own. The court held that the role elected officials play in society makes it all the more imperative that they be allowed to express themselves on matters of public importance. Barrett's expression shifted subtly from disapproval to reluctant engagement. Miss Leavitt, you've cited several cases, but none specifically address statements made by White House officials about Supreme Court decisions. That's correct, Justice Barrett, Leavitt acknowledged. But the absence of specific precedent restricting such speech should favor protection rather than limitation. As this court noted in Texas v. Johnson, 1989, we have a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Justice Clarence Thomas, who rarely spoke during proceedings, broke his silence. Miss Leavitt, while your legal analysis is thorough, there remains the question of respect for institutions. Your statements could undermine public confidence in the judiciary. Leavitt turned to Thomas. Justice Thomas, I deeply respect your concern. However, in Landmark Communications v. Virginia, 1978, this court stated that injury to official reputation is an insufficient reason for repressing speech that would otherwise be free. The opinion further noted that the law gives no protection to judges who would hide behind the cloak of office to escape public criticism. The quote hung in the air, its directness causing several justices to shift in their seats. Leavitt pressed on, citing historical examples to bolster her case. Throughout our nation's history, tensions between the executive branch and this court have resulted in far more pointed criticisms than mine without contempt proceedings. President Jefferson called Chief Justice Marshall's opinion in Marbury v. Madison twistifications. President Lincoln challenged the legitimacy of Dred Scott v. Sanford in his inaugural address. In 2010, President Obama criticized Citizens United during his State of the Union address, with 6 justices present. None faced contempt, Justice Sotomayor interjected. Those were statements by presidents, Miss Leavitt. Your position as press secretary is different. Respectfully, Justice Sotomayor, Leavitt responded, the legal standard for contempt does not create a separate category for presidential speech versus other executive officials. Historically, press secretaries like Ron Ziegler under Nixon and James Brady under Reagan issued statements critical of Supreme Court rulings without facing contempt. Leavitt then delivered her most powerful argument, analyzing her exact words from the press briefing. I stated that the Fairfield ruling represents a fundamental misreading of precedent and legislative intent. This is a legal assessment, not a personal attack. I said the majority opinion ignores 70 years of established jurisprudence. This is a claim about legal methodology, not judicial integrity. Under Bridges, contempt requires a clear and present danger to the administration of justice. My statements present no such danger. Barrett, who had entered the chamber confident in her position, now faced an unexpected challenge. Miss Leavitt, she said, as White House press secretary, Your words carry the implied authority of the executive branch. Leavitt seized the opening. Justice Barrett in Garcetti versus Ceballos, 2006. This court held that public employees' speech pursuant to official duties may receive less First Amendment protection. However, Lane versus Franks, 2014, clarified that speech on matters of public concern deserves robust protection. A Supreme Court decision affecting national education policy is unquestionably a matter of public concern. My role inherently involves communicating the administration's positions on such matters. The chamber was spellbound. What had begun as a disciplinary proceeding had transformed into a masterclass in First Amendment jurisprudence. Barrett tried to redirect. Miss Leavitt, this court has the authority to defend its institutional integrity. Your statements, regardless of their legal status, showed disrespect. Leavitt nodded respectfully before delivering a stunning blow. Justice Barrett, I have the deepest respect for this court. It is precisely because of that respect that I believe we must engage in robust debate about its decisions. As you wrote in your 2019 Notre Dame Law Review article, respectful disagreement is not disrespect. Indeed, the ability to criticize judicial reasoning is essential to the health of our constitutional democracy. The chamber fell silent. Barrett's own words, quoted verbatim, had turned the tables. Several justices glanced at Barrett, awaiting her response. After a long pause, she spoke. Miss Leavitt, I appreciate the thoroughness of your presentation. The court will need to consider the points you've raised. Chief Justice Roberts addressed Leavitt. This court will take your arguments under advisement. We'll issue our determination within 48 hours. This proceeding is adjourned. As the justices exited, the gallery erupted in whispers. Legal observers, expecting a reprimand, had witnessed something extraordinary. A young press secretary had transformed a contempt proceeding into a constitutional debate, using the court's own precedents with remarkable precision. Outside, Leavitt faced a sea of reporters. I've presented my position to the court, she said calmly. Out of respect for their deliberative process, I'll reserve further comment until their determination. Her measured response only amplified the impact of her performance. Within hours, legal experts were dissecting the confrontation. Georgetown's Professor Lawrence Tribe called it unprecedented, noting Leavitt's remarkable precision. CNN's Jeffrey Toobin declared, she delivered a guest lecture on First Amendment jurisprudence to the justices themselves. Even conservative commentators like former Judge Michael Luttig praised her well-crafted defense. The revelation of Leavitt's legal background, completed quietly while working in government, added to the narrative. The Washington Post published a profile detailing her 3.9 GPA and her former professor's praise. One of the most gifted constitutional law students I've encountered. Inside the White House, the mood shifted from concern to optimism. A senior advisor admitted, we had an apology ready. Nobody knew she'd spent the weekend building a constitutional defense. The president called Leavitt personally, saying, you made history today. I'm proud to have you representing this administration. 48 hours later, the Supreme Court issued a unanimous 9-0 decision not to pursue contempt proceedings. The brief statement acknowledged the important First Amendment considerations raised by Leavitt and reaffirmed the protection of robust debate. Justice Barrett's concurrence became a landmark. While this court maintains its authority to protect judicial proceedings, we must respect constitutional boundaries. Ms. Leavitt's presentation reminded us that our precedents protect critical commentary, even when harsh. A democracy that cannot tolerate criticism of its courts is no democracy at all. The decision was a personal vindication for Leavitt and a significant affirmation of free speech. Legal historians marked it as a defining moment in executive-judicial relations. At her next press briefing, Leavitt remained composed, stating, "I'm grateful the justices engaged thoughtfully with the constitutional questions. The confrontation had far-reaching effects. Law schools reported surging applications, particularly from women inspired by Leavitt's poise. Constitutional law courses saw increased interest in First Amendment and separation of powers issues. Future administrations became more precise in criticizing court decisions, focusing on legal reasoning rather than motives. The court, in turn, grew more restrained in responding to executive criticism, mindful of the boundaries Leavitt had highlighted. 6 months later, Barrett invited Leavitt to speak at Notre Dame Law School. The sold-out event symbolized their transformation from adversaries to participants in constitutional dialogue. Barrett introduced her. Miss Leavitt reminded us that robust debate strengthens our system. Her legal acumen surprised many, but it shouldn't have. In America, brilliance can emerge from unexpected places. As Leavitt took the podium to thunderous applause, her journey from potential contempt defendant to respected constitutional voice was complete. What began as an attempt to silence criticism had amplified it, establishing a new precedent for protected political speech.